Good day, ladies and gentlemen, and welcome back to another What If session. My name is Veer, and today's topic is: what if a chairperson of a disciplinary hearing imposes an incorrect sanction? Can an employer substitute the sanction? Now, to unpack this, let us discuss the following scenario. You have an employee. The employee is employed in a position of trust. The employee is now charged with dishonesty, and in terms of your disciplinary code, dishonesty is a dismissible offense, even if it is the employee's first transgression. In the disciplinary hearing, your chairperson finds the employee guilty. However, he or she decides not to dismiss, but decides on a final written warning. In considering what the appropriate sanction would be, the chairperson only considered the employee's mitigating factors as well as irrelevant factors in deciding that dismissal is not appropriate. The chairperson failed to consider the aggravating factors of the employer. He or she failed to consider the position that the employee occupies. He failed to consider the fact that the conduct of the employee resulted in a breach of the trust relationship, and he or she also failed to consider the gravity of the offense. The question in this scenario, or in considering this scenario, is now whether you as the employer can substitute or review this clearly incorrect sanction imposed by the chairperson. Now, in determining whether you can substitute a decision on sanction, we need to distinguish between two scenarios. Scenario one is either where you have a disciplinary code and the code provides for a substitution or review, or you have a code in place but the code is silent on whether a disciplinary hearing chairperson is given final decision-making powers. That's the first scenario. The second scenario is where you do have a disciplinary code in place, but the disciplinary code is also a collective agreement. In other words, the disciplinary code is a written agreement between employer and trade union. Now, where a disciplinary code is silent on whether a disciplinary hearing chairperson is given this final decision-making powers, there would be nothing which would prevent an employer from reviewing the sanction in circumstances where it is not satisfied with the chairperson's finding on sanction, as per the scenario that we have just explained. However, this option, the option to review or substitute, should only be used in exceptional circumstances, and it should always be subject to considerations of fairness. If, however, your disciplinary code is also a collective agreement, the provisions of the collective agreement will regulate whether the employer can overturn the chairperson's decision or not. If it does not regulate it, ladies and gentlemen, silence on this issue will not be sufficient to warrant an employer's interference with such a decision. In other words, even if your disciplinary code is a collective agreement, if it regulates the review or substitution, that's fine, you can do it. If it does not regulate it, you cannot interfere with the chairperson's decision because of the fact that it is a collective agreement. Now, let's assume that you as the employer have a disciplinary code in place, and it either provides for the review or substitution, or it is silent on whether a disciplinary hearing chairperson is given final decision-making powers. You as the employer will then be able to review or substitute the sanction imposed. And as mentioned earlier, this option should only be used in exceptional circumstances and subject to the considerations of fairness. Now, in this regard, the following must be determined. Was the sanction of the chairperson inappropriate, irrational, unjustifiable, and out of line with the employer's precepts, precedent, and practice? Accordingly, an employer will only be able to review or substitute a chairperson sanction if 1. The disciplinary code is not a collective agreement and is either silent on whether a disciplinary hearing chairperson is given final decision-making powers, or it provides for a review or substitution, and number 2, the chairperson's sanction was inappropriate, it was irrational, unjustifiable, and out of line with the employer's precepts, precedent, and practice. Obviously included in this is also whether, even if it is a collective agreement, the collective agreement specifically provides for the review or substitution. The next question is, if I can review or substitute, is there a type of process I need to follow? The answer is yes, and we would definitely advise the following process. 1, you should inform the employee that the sanction is reviewed. 2, you should inform the employee of the reasons for the review, whatever it is. 3, you should inform the employee that he or she has the opportunity to appear before the final decision maker to present reasons why he or she should not be dismissed. And then finally, you should allow the final decision maker to consider the reasons provided by the employee and then to make the decision. Please bear in mind, the review or substitution, there is now a new decision maker, and therefore we need to give the employee an opportunity to provide reasons why he or she should not be dismissed to this new decision maker, not the chairperson of the disciplinary hearing. Ladies and gentlemen, I hope that you have found this video useful. That then brings us to the end of this video. As always, should you have any queries in this regard, please do not hesitate to contact us. Thank you for joining us today. I do hope to see you soon. Bye-bye.